trust modification and early termination. In terms of understanding the rules for modification and early termination, we need to first understand whether or not we're dealing with a testamentary or inter vivos trust. Testamentary will always be irrevocable because it's not created until the death of the testator, or inter vivos, and if inter vivos, is it revocable or irrevocable? In terms of review from the spendthrift provision, keep in mind that they are included to keep the beneficiary's creditors away from the trust assets, allow the trustee to manage the trust in accordance with the trust terms without being worried about being personally liable, like was the case in Wilcox for making a distribution. The mandatory distributions cannot be withheld to prevent the creditor from taking. It has to be distributed so the creditor can have a chance to get it from the beneficiary. We also realize that some creditors will be exempt from spendthrift provisions, and they include self-settled necessities, alimony, child support, and taxes. All right, so let's talk about termination. Again, how do we have, with an inter vivos trust, is it revocable or irrevocable? A testamentary trust will always be irrevocable. Remember that the default, if the inter vivos trust is silent, is under common law, it's irrevocable, but now with the Trust Act and the Uniform Trust Code, it is revocable. How are we going to revoke? Well, revocable, it seems pretty easy. Of course it would be revocable. However, you can't revoke an inter vivos trust, which is an inter vivos document, with a testamentary document, and that typically is what happens. If it's irrevocable, either because it's created at the death through a will, or by it was irrevocable at the creation, there's a three-part test that needs to be satisfied in order for the trust to be revoked. All the beneficiaries in interest must consent, the settler's purpose must be carried out, and the settler's intent followed. So it's very important for you to understand whether or not you're dealing with revocable or irrevocable in terms of termination, premature termination or modification. The Connecticut General case is a 1977 case, and it predates the Trust Acts. So what happened here was a life insurance trust was set up for the benefit of a spouse. Then there was a divorce. Currently, that divorce will automatically revoke the provisions relating to the now ex-spouse. But this was in 1977, and that didn't happen. The settlor attempted to revoke his revocable trust by will, and that didn't work, okay? Because it's like night and day. You've got an inter vivos trust, you must follow the trust terms, you must revoke it or modify it during lifetime, not at death. But keep in mind, there is automatic revocation with respect to a divorce now that has always been in wills and has recently been extended to trusts. Take a look at the language. What were the rules that the settlor imposed on himself? Probably boilerplate language. Maybe the settlor didn't even read it, but he certainly didn't follow it. You got to follow your own rules. How is this case different from Clymer v. Mayo, which we looked at earlier in the trust chapter? This court took a completely different approach than the court did in Clymer v. Mayo. And how can we sort of reconcile those two differences? Again, the one thing that I will continue to emphasize is that you cannot revoke a inter vivos trust or any inter vivos arrangement by will. They must be modified or revoked during lifetime. In order to terminate by beneficiaries, because let's say it's irrevocable and the settler is out of the picture, there is a 3-part test that needs to be satisfied. The Adams v. Link case is the ideal situation. We had a trust set up for Mays Vopel, and then upon her death, it was going to the New York Association for the Blind. Everyone was impatient. They wanted to terminate prematurely. And the question was, could they? And again, remember, all the beneficiaries in interest consenting, the settler's purpose is accomplished and the intent carried out. So if we have all the beneficiaries in interest and then some, not clear where the heirs, why the heirs needed to sign off on this, but we had both Mays Vopel and the New York Association for the Blind saying, yeah, let's terminate. But the trustee says no. So the question becomes, we have all the beneficiaries in interest consenting. Is the settler's purpose carried out and intent being followed? And the court says no. We can't, just because everybody that's affected wants to prematurely terminate, doesn't mean that that would have been something that the settler wanted. So they hold no termination because the settler's purpose in setting up a trust for the benefit of Mays Vopel for life was to provide her a life enjoyment of the property. And if we give it to Mays Vopel outright, it could be lost or spent and not provide her with that benefit for life. In that particular case, they did not have a spendthrift provision, and they said it would be even a stronger case against termination. That is no longer the case because by statute, both the Maryland Trust Act and the Uniform Trust Code permit premature termination, even if a spendthrift provision is part of the terms. The next case dealing with premature termination, they allowed termination in a situation in which a trust was set up for the Millers for $200 a month to do what? To assist with the education of their children who were entitled to a percentage of the trust at various ages. All of the children had reached such age, and secondly, Mr. Miller had assigned any right that he might have had to the $200 a month. That was the key. Could the trustee object? In this case, they remember, if the trust terminates early, the trustee is no longer getting paid. So we are a little suspicious when the trustee is objecting, and we want to know, hey, is this a greedy trustee or is this a legitimate? In this case, they say that premature early termination was accepted. Trustee doesn't need to be paid anymore. Mr. Miller had waived his rights. All of the children had reached their various ages. Therefore, termination was allowed. We look at modification of administrative powers, which is in the next section. Look at the problem. The modification and reform of trusts have become easier than a will, as long as, again, by statute, they carry out and further the purpose of the trust. There can be some modification.